Hello, friends. Welcome to Investment Immigration Conversations. I'm your host, principal and founder of Carolyn Lee, Pllc, the namesake, Carolyn Lee. I am just going to hit right into our year-end webcast. This is a tradition that we have had at CLP since I founded the firm in 2019, where I invite friends and respected voices in the industry to really honor the year that we have had in EB-5 and look back and evaluate some of the highlights from our perspective. And this year, year two post RIA, has been extraordinary. And of course, we're going to hit the January 2025 Visa Bulletin. That is really going to set the stage for 2025, right, in a big way. And we're also going to hit the litigation. Litigation has been, really big sort of industry place-holding events, including, of course, the one on sustainment. And the other litigation that's pending is on Visa numbers, these precious numbers, trying to preserve the carryovers that are in unreserved within the unreserved category so they don't fall up under the operation of the INA. And market changes. Year two in the RIA, there have been developments and trends that have shifted and shaped the investment products that are in the market today in terms of the duration of investment periods and the returns that are promised or not promised, because these are all at-risk investments, but that the potential of the returns and the different ranges we're seeing a greater variety. There's a richer texture to the investments that are out there. On that point, we're not giving any sort of advice whatsoever. And CLP itself is a law firm, and all we do is investment immigration law. We don't engage in any other kind of service. So with that, let me just kind of go around the horn and ask folks to introduce him and herself. Let me start with Suzanne. Suzanne, everyone knows you, but I would love for you to say a couple of words about how you would like to introduce yourself and what you do in this space.
Well, I'm a business plan writer working with EB-5 historically, and also working with non-immigrant and other categories now, and observing and writing reporting on EB-5, collecting data as part of my writing at the Lucid text blog.
Understated as ever. Lee, please tell us about you.
Of course, happy to. My name is Lee. I'm the Director of Policy Research and Data Analytics at IIUSA. I realize this may be the last webinar between you and the new year, but I know all of you are very excited to talk about numbers, as we have a lot of numbers to share with you all. 2024 has been a remarkable year for EB-5, but I'm very excited for 2025 as well, because it's going to be my 10th year with IIUSA next year. But looking back, I've learned a lot from Suzanne and Carolyn in my past 9 years with IIUSA, and look forward to learning more from Dilip today and moving forward. Happy to be here. Thank you for inviting me.
Thank you so much, Lee. Dilip, tell us about you.
Oh, thank you, Caroline, for having me. Hi, everybody. My name is Dilip. I am an EB-5 investor. That's the most important thing you should know about me. I invested in 2017, and I got my conditional green card in 2022. It took 5 long years, including the lapse in between. And then along the way, I met a number of other EB-5 investors. And I realized that not everyone, in fact, most of us were not prepared for this journey, whether in terms of immigration or in terms of investment. And I come from an investment banking background, so I took it upon myself to write a book, which has just been published. It's called The Essential EB-5 Investor's Guide. It's available on Amazon. It covers the immigration and the investment aspects, because a lot of us come from various walks of life. There are software engineers and oil engineers and all kinds of people, and we don't really know what to expect in the EB-5 journey, how to evaluate investments. So my objective in this book is to lay out the essential knowledge that every EB-5 investor should have before jumping into the pool. And it's been vetted by 2 attorneys, and Suzanne has contributed and reviewed the book. So I'm happy to have it out there, and please check it out.
Dilip, I feel like that was a beautiful introduction to what you do and your approach and how you're coming into being an observer in this space. And I just want to start with, because I think this is going to kind of set the stage for the rest of our discussion. What do you think? I mean, what would be the top 2 or 3 essential things that an EB-5 investor should consider before filing his or her case, before making his or her investment?
I would say, to start with, have a good overview of the EB-5 immigration process. It is a multi-step process, and there are various delays and problems that could arise in each of these steps. So therefore, have a good overview of what this process entails. Number 2, I would say, look at the numbers and then have a good view. Come to your own view on how long you may have to wait. If you are the next EB-5 investor, you are really joining the back of the queue. So how many people are waiting before you is an essential information you must have. All the salespeople will show you just the Visa Bulletin and say, hey, look, it's current. But that's completely meaningless, because there is a hidden queue that's already lining up to reach that Visa stage. And you should know how many people are waiting and where you could be stuck. That's number 2. And number 3, as far as investments are concerned, there are so many things that could get very complex. There could be multiple entities, multiple levels, one holding company holding another company. What is the collateral? What are the investment returns? How do you put all this together and evaluate an investment? That's something you should educate yourself on. That would be my top 3 pieces of advice to any potential investor.
And that is awesome. And we're gonna hit number 2 right now, the numbers, understanding the numbers. So Suzanne, Dilip just mentioned the invisible backlog ahead of the investor who's investing today and filing the case today. Tell us about this. What is the invisible backlog?
Well, there's the total backlog, which means everyone who filed I-526, I-526E, and is going to have priority to get a visa before you and doesn't have a visa yet. That's the total backlog. The invisible part is the people who are still at USCIS waiting for their I-526, I-526E petition to get looked at. And we call them invisible because the Visa Bulletin does not really consider those people because they're not ready yet to apply for a visa. And we also have to do some guesswork to guess one investor with one I-526 filed, how many visas is that case going to end up demanding? And the invisible backlog is important when there are a lot of people who are still at the stage of waiting for I-526 approval, which is the case for most high unemployment and rural investors, since we've only had about 1,000 petitions filed to date.
What makes it invisible?
The 2 things that make it invisible are, one is that the Visa Bulletin does not report on it. And so if people are looking at the Visa Bulletin as their total signal, is there a backlog? They should know that all those petitions at USCIS pending, those are not considered in the Visa Bulletin dates because these people are still waiting for their initial petition approval, so they can't apply for a visa yet. And the other thing that makes it invisible is that it's hard to get the data on it, although IIUSA and AIIA have managed to get some numbers as far as how many people are waiting in the various queues.
Okay, now
if I may just jump in for 1 second
yeah.
here. When I think about the invisible backlog, Susan, I also include in my mind one more thing, which is the number of people waiting at the NVC. So your I-526 has been sanctioned, approved, but you still don't have a visa. There are quite a number of them at NVC. Right.
Although that's visible to some extent because we have the number of applicants who are registered at NBC. So we have a little bit more information, but yes, definitely when someone's thinking about the total backlog, they want to be thinking about how many people are registered at NBC, how many people have their I-485 pending, and how many people have their I-526 pending.
And,
That's
If I
fantastic.
may
Yes,
quickly comment
right on
here.
cue.
I feel like for the invisible part, it's less invisible these days because of all the work that we have been doing here as a group. We have a lot of information right now published. So not only just the proof numbers that we are seeing, as Suzanne mentioned, registered in the NVC, and also is accounted for on the Visa Bulletin, are visible right now. But a lot of filing numbers are visible to investors right now. To Dilip's second point is that a lot of information are available. We also know how many people have filed their 526Es, under which categories, from which country. It's all about transparency, I would say right now. So there are a lot of information out there and a lot of investors to really take the opportunities to get more information.
Yes,
You
that's
know,
a very good point.
that is a really, really good point. And I think I agree. It is about transparency. It's also about transparency in terms of, okay, so we have the data, we need that. We need to do a better job on getting that information without suing. But once we have it, it's such a huge data download that parsing and analyzing and then sharing out the actionable, they're almost sound bites. I mean, what are the points that we can distill all of this data into? But which gets to Dilip's second question, what is the queue ahead of you? But before we do that, can we talk a little bit about method? What is the nature of the data that we are getting? How are we getting it? And how do we crunch through it so that we can get a feel for that queue?
Well, since the passing of since the legislation of the RIA, the queue has really split into two portions, right? There's pre-RIA, how many people are waiting, how quickly are they being approved or denied, and then they go on to receive their visas. So at what stage are they stuck? So that's one completely separate queue. And then there's the post-RIA, which then splits into different categories. There's the rural, there's high unemployment, and then from different countries and so on. So now, because it's a lot more complex post-RIA, and there's also the carryover provisions. If these reserved visas are not used in 1 year, they carry over to the same category the next year, but in the third year, they are released to the unreserved queue. So you have to consider that as well. So when you talk about demand, there are all these people filing rural high unemployment petitions from all around the world. And then you have this supply where there are these visas, but then they could be carried over. So you have to put these complex pieces together to figure out, okay, if I file a rural petition today, I'm from India, I'm from China, I'm from Vietnam.
Okay,
how long do I have to wait?
That's super important. So that's the sort of the structure, right? We need to start with the structure that these numbers have come into. What else? What's the process? What is the data? And well, the data, I guess Suzanne has addressed. It's the number of cases pending at USCIS, the number of cases that are reported to be at NBC, and the number of dependents and the country of nationality, right? What else? What else, Lee?
So if I can maybe step back a little bit, so
Mhm.
there are a lot of information now USCIS published right now, what we call published data or public data. So based on our analysis, so USCIS published the quarterly data for 526 and 526Es, case filings, case approvals, case pending. So those are the public data that's available. So it's like over 6,000 526 and post-RIA 526Es case has been filed in the last 2 years. So those are the information that's publicly available. However, what we don't know is like how many of that 6,000 petition is under rural or under high unemployment or under nothing is under infrastructure, I don't think, but under unreserved categories. From which country that is not publicly available is unknown. So IIUSA and also AIIA has been doing a lot of what we call FOIA requests, like Freedom of Information Act. request USCIS to provide us those numbers, the breakdown of the 6,000 petitions. So we all have this information.
How about the number of dependents? Because that's also important. And now that's not a number that we'll know until they're at the NVC stage, but is this a number that we can ask for from USCIS or no?
I don't think we can ask for the future numbers of dependents, but we can ask the historic data. Like for example, like how many dependents has used the EB-5 numbers in the past year, like 2024 or 2023 or before. But I don't think we can ask them for forecast how many dependents we'll be using.
I'm just going to put it out here. I think we can. It's it might be like a bridge too far, or maybe it's like a next phase of requests. But this is information that is collected on the 526E form. So I think if we, the requesters of the information, have the will to like take that step and ask for it, it is certainly being collected. We could ask for it and we could get it.
I wrote an article about this recently because I think that this is really a key piece of information, and also it's a key differentiator. If you're two different experts crunching the numbers very differently and coming up with very different conclusions about what is the backlog, often where they disagree is what is this multiplier that where you get from investors to number of visas. They disagree about the and so I collected the last 7 years of historical information from two sources. One from Department of State, which gives a breakdown of right now for everyone at NVC, how many dependents per principal. And then the other thing, your book of immigration statistics, they do a detailed breakdown, how many spouses, how many children, both consular processing and adjustment of status. And the historical trend, the history is consistent enough that I feel like we can pretty much use it for projections to the future.
Okay. And are the panel, do we generally here agree? It seems like we're saying that the multiplier is like, for the set-asides, is a little under 3. Lee, Dilip, Suzanne, would you say? Do we agree on that ballpark?
Go ahead.
Oh, I would agree generally. So 3 has been the multiplier that we have been using for pre-RIA EB-5 petitions, like petitions to visa ratio. However, based on what I'm hearing, I think the multiplier may drop a little bit after the RIA because of all the concurrent filings. Right now we are seeing for EB-5, especially for the investor group has shifted a little bit based on the, again, not hard data, but the conversations that we have with our members. A lot of the investors right now, they're already in the US. They're students, so they may not be using free visas because they may not have kids and may not be married yet. A lot of investors are also H-1B holders right now. So that means maybe their kids were born in the US, so they're not going to use the 3rd or the 4th visa. So based on these conversations, I suspect the ratio would be more or less way lower than, not way lower, less than 3.
Yeah. Suzanne, Dilip, would you agree with that? Because that's my sense too. It's like under 3.
I mean, broadly speaking, it's the principal investor plus 2 derivatives. So that's how we get to 3. And I would agree with Lee that it's probably trending lower, but we must remember that, of course, after the concurrent filing became possible, more and more people are investing in EB-5 from the US itself. But then there is still a number of investors coming from overseas, and that, therefore their number of dependents, that's not going to change. So on a weighted average basis, yeah, one can expect a little bit of a trend down, but not like very drastic. That's what I expect.
Okay.
Yeah.
All right.
I do recommend my article if anyone wants to drill down into the numbers, because we do have good data on this. And there is definitely a difference between average family sizes and adjustment of status versus consular processing. The number that's close to 3, we get that from consular processing. The number for adjustment of status is lower, but it is because of the proportion of consular processing to adjustment of status, the average overall is more like in the 2.5, 2.6 range. And it's also interesting that the adjustment of status, recently it had an uptick. And I wonder if that's because young people are starting to get married and have children. And so people who were over time, that the adjustment of status number may get higher while the consular processing number has consistently gone down, which I guess is due to children aging out, growing up, the fact that the people through consular processing. So for me personally, I think that the family size more like 2.5, and when you add on the attrition on top of that, personally, I'm comfortable with going as low as 2.
Wow.
But I don't think you can safely go under 2 personally. And
yeah,
some people do that for their estimates. So
wow. Okay. I mean, I'm kind of using like 2.8, 2.9.
2.8, 2.9 is the average for consular processing.
Yeah, and then you factor in adjustment, you can comfortably go a little lower. Okay, so that's roughly the methodology and the data points. Let's just get right to it. So, what is the queue? And then talk about how is that queue going to play out? What is the invisible backlog in rural, and what is it in front of high unemployment? Opening it up to you guys. Lee.
Well, I will try my best to talk a little bit about this. So because it's invisible, so it relies on a lot of assumptions. So we just talk about our assumptions on the family size right now. So we what I love to do is instead of using one number, I use a range. So let's assume family size is from 2.25 to like 2.6 or 2.7 even. How would that change the calculation of the number of people rated in line based on the case file and numbers? So based on this approach, I have my matrix taking account if we have 2.25 numbers. And then let's see here. I have my spreadsheets ready. So based on the data that we have, right now we have over 2,200 506 filings associated with the rural area. And then if we use 2.25 as the household family size, and let's assume that 95% of those cases would be approved by USCIS, that gives us close to 5,000 applicants.
On the low
is
end,
rated in line right now.
in rural,
right?
On the low end,
on rural and the low end.
from
yes.
incept, from the passage of the RIA.
Correct. Yes.
Okay.
And then if we change that, for example, I just want to illustrate the difference of different multipliers. How would that change the calculation?
Yeah.
If we use 2.6.
Yeah. 2.6. I'm writing this down. First, give us the 2.25 again, just so we can have that number for comparison.
Sure. Again, 2.25 family size, 95% approval of 5 to 6 years. That gives us close to 4,900 applicants.
Okay.
Within in line.
4,900 rural. Okay.
Then if we want to be conservative, we say like 2.7 even.
Yeah.
So it's close to 5,900.
5,900.
So the difference is like 1,000 visas.
That's meaningful because we have 3,200 annually in a normal year. So that's a third. Okay. Okay. So that's rural. How about HUA?
So HUA, again, based on our numbers, we have 3,500 526 and 526E petition file under HUA. If we use 2.25, and again, 95% approval rate is 7,400.
7,400. Okay. Yep.
And then if we use 2.7, it will be 8,800. 8,800. And like under either case or scenarios, the demand is way higher than the visa available, at least in the next few years.
Oh yeah, for sure. Okay, so let's break this down a little bit. So just to recap, folks, and let's talk the upper range. The upper range, based on a multiplier of 2.7 for rural, is about 5,900. That's the invisible Q in the upper end for rural. For HUA, the upper end is 8,800. Now, we have to just one thing, the upper end, these are Lee's upper end numbers, which, okay, it's the multiplier is 2.7. So there's going to be a little bit of an adjustment there if you're more conservative and your upper end is a bigger multiplier, like maybe mine and maybe Suzanne's. Can we talk about that for just a moment? Because I think, yes, Dilip, go ahead.
Wondering, these numbers that you just gave out, as of what date are you reporting these numbers? What date?
Oh, it's as of, you mean the 5 to 6 e-filing date?
Right.
Yeah, I mean, these numbers that you just...
July 5th, July 5th, 2024, yeah.
Yeah.
Okay.
A clarification on that too. It's that is the date when you received the data, but
Yeah,
AIIA also has numbers that counted more than that, and I think it's
that's
just
one.
because they take a long time to enter into the database at USCIS. So if you get a query that's later, it'll get more.
I think that's
but
why,
it's
Suzanne,
important.
your numbers are bigger, right? Because can you just, so this is important. Lee's numbers are based on data reported in from July 2024. And so that's the cutoff, right, Lee? That's like
Yes,
the
correct.
526 is in as of July. AIIA's FOIA request got data that cuts off later. September when?
Their data also is through July, but it's just based on a query of the database that occurred later.
But
And
the query then pulled in more numbers, right? It
Right.
had that, okay.
Right. But I think that it's so easy to get in these discussions too, to all of a sudden get into the small detail. But
Yes, true.
Even the big picture, even if we just go, let's go the lowest count, the most conservative assumptions on family sizes, we're still dealing with a backlog.
All right, we for sure are, but I do want to just like cover some of the technical points here.
Right.
Using the data that's been pulled in September, Suzanne, I just want to talk about your numbers because they are a little different. They're a little higher, I think, than Lee's numbers. What are yours in the range, like for rural and high unemployment?
As far as the visa demand, I personally come up with a similar bottom line calculation, but
okay.
The I-526E numbers I'm feeding in are a few hundred higher. And then it's
Right.
important to remember too that 5 months have passed
since then.
Yes, and we know from the most recent USCIS report that over 1,000 I-526E were filed just from July to September.
Right. Okay.
So
All right.
things are coming in quickly.
So then let's okay, exactly. This is important. This is very dynamic. We're not, it's not fixed at 8,800. Okay, there's more ahead, ever more. But so then let's kind of come back to these numbers, because coming back to Dilip's question, what is the invisible backlog ahead of an investor coming in today? How do we evaluate these numbers? So once again, on the high end, we're talking about 5,900 in rural, with a grain of salt, right? Because these numbers are dynamic. In high unemployment, 8,800 roughly. What does this mean? Now we have a feeling for the numbers ahead. How do we break this down?
Well, to me, it always shows like how popular EB-5 is and how Visa is not enough to justify the demand for the program. So it's to me, it's the reality. It's just like EB-5 is super popular. It's not even at its peak right now, but just the reserve number, the reserve visas are not sufficient and enough to justify this demand. So
and just for our audience to break down what Lee's point is just now, it means let's look at the supply. The supply for these numbers is this. We have about 9,940 annually, normally. Of those, 32% are set aside for rural, high unemployment, and infrastructure in these proportions. So it's 32% for those three categories, 20% for rural, 10% for high unemployment, and 2% for infrastructure. So that means roughly 2,000 for rural in a normal year, roughly 1,000 in a normal year for high unemployment, and about 200 in a normal year for infrastructure. That's what Lee means when he says that the supply is far smaller than the demand, as we see from these numbers.
So when you're making your little calculation on the napkin,
Yeah,
if you think that there are 8,000 demand for 8,000 high unemployment visas, that's your numerator, and then the denominator, at what rate can those be issued? So you
yeah,
by 1,000 because they can, and so that gives you 8 years, but then you can subtract
8.8
year because we're going to have 1 year with double the amount. Thanks.
this year.
So that would be a 7-year backlog if people were going through one by one and there wasn't any country cap issue. That would be 7 years worth of high unemployment visas. And where it gets complicated is that in real life, number one, as soon as we get too many people at the visa stage, the red light is going to go on for China and India to hold back applicants from China and India, so rest of the world can go first. So that means China and India could wait longer, the world could wait shorter. The other thing is that many, if not all, people who are high employment investors also have the unreserved code on their approval letter. So there's a question of at what point could it be possible that it might be faster to choose to get an unreserved visa than a high unemployment visa. And for there, you need to then go over and look at, well, how many people are standing in line for unreserved visas now, and how long will it take those backlogs to clear?
Let's just pause a moment on yes, Dilip, please.
Just on that point, I've heard many regional center sales people saying that backlog is not that bad because a lot of these reserved visa applicants will actually choose to go to unreserved queues. I'm very, very skeptical about it. Now think about if you're a reserved quota investor, if you're from China and India, why would you go to the unreserved queue? Because there's a long queue ahead of you already in the unreserved. And we haven't really dug into the numbers of the unreserved queue here, not yet, but that's really, really long. And then even if you're from the rest of the world, again, why would you go and join the queue right at the back for the unreserved? I'm very skeptical about whether any investor would choose an unreserved voluntarily when the choice is to just stick to rural or high unemployment.
I feel like this is a detour worth taking from the ultimate question of how long is the invisible backlog? Can we pause it? Can we take this segue into the unreserved numbers a bit? Dilip asked the question, why would somebody who has the choice of taking down a set aside number, under what circumstances would they choose to go into the unreserved? Can Lee and Suzanne, can you address that? Under what circumstances would an investor who has the option of going into either elect to go into unreserved?
I can try the first crack, and Suzanne can always complete my thought if not say it better. So I think if I am not from China or India, switch the line from reserved to unreserved is very appealing to me, because it's very unlikely there will be any cutoff day for the unreserved outside of China and India.
It would be altruism, though. Am I right?
Yeah. And
okay.
I mean, looking at all the supplies right now, so it's always, again, we don't talk about Visa Bulletin, but according to Visa Bulletin, it's always current for rest of the world under unreserved.
If I was a Canadian.
Yeah,
right?
And in fact, I look at the numbers every month for the visa issuance numbers. In fact, a lot of investors, I saw 5 investors from Taiwan already using the unreserved category. So is under the new label, new symbol.
Mhm,
So right now, when the consulate office they process these visas, instead of just using the old symbols for regular EB-5, they have a new symbol for unreserved EB-5. And
Right.
based on this new symbol, I tracked them down 5 new post-RIA unreserved visa has been issued in Taipei consulate office. That means investors from Taiwan could have invested in the reserve category, but they choose to process their visa under the unreserved because maybe they will worry about there could be a cutoff day for the reserve category, so they would just switch to the unreserved for better protection.
What do you think, Suzanne? What are the circumstances under which an investor might choose to go into the unreserved?
Okay, as far as right now, if they would choose, I agree with Lee that in fact, some post-RIA investors have been getting unreserved visas recently. So apparently for whatever reason, some people are doing it. If I were a rest of the world investor, I would not choose unreserved because looking at the data in front of me that says there are 9,000 pre-RIA rest of world investors queued up for unreserved visas. So if consulates were issuing visas in order to rest of the world, scheduling visas in priority date order, I would have to wait a long time for my turn to come while I wait for all those people from 2018, 2019, 2020, 2021, 2022 for them to get their visas before I get scheduled. The fact that we are seeing a few unreserved visas for post-RIA people, though, I don't know if that means that the consulates are willing to go out of order but there are a lot of pre-RIA people in line right now.
This is really good information, Suzanne. Let's just pause a minute on this. So how many are from the rest of world in the unreserved queue right now at NBC?
I'll break this down.
Yeah.
This is as of May 2024, which is when we have the specific numbers. There were 5,711 rest of world at NBC.
Yeah. But in unreserved only?
Yeah.
Yeah.
Because these are pre-RIA.
Yeah.
So the people who invested before 2022 are all getting unreserved visas. They have no choice. So,
right.
And then for pending I-45 is about 1,400. And then my estimate of the number of applicants from visas from pending I-526 is about 2,200.
Visas. So you've applied a multiplier already.
Applied a multiplier. And
so what's that number again?
The number
based
of
on pending 526s?
Yeah. The pending I-526s was 1,049 at that point. So I just assumed a 78% approval rate and 2.78 family size, which was average at the time, to come up with about 2,200, 2,300 visas.
So let's say 2,200. Okay.
Ballpark, that's adding up to over 9,000 people pre-RIA in line for unreserved just from rest of the world. And then
rest of world.
China and India today, nobody would have incentive to choose unreserved just because there are around 7.
I mean, there's a cutoff already for sure.
But
so
I do foresee that in 2031, 2032, Indians are going to, I think that the pre-RIA backlog can be cleared by that time. And at that point, it will be faster for Indians to take an unreserved visa than keep waiting in line for
2031. So 6 years from now.
Long time.
Okay. Well,
2025 is coming up.
I think we should also think about the process through which an investor could choose either one, right?
Yeah.
Please correct me if I'm wrong, but as far as I understand, it is only the consular processing investors who are given this choice. When they receive a welcome letter, then they choose which one they want to stick to. Do you want to stick to rural? Do you want to stick to, or do you want to move to unreserved? You can make a choice at that point. I'm not sure that choice is available to 485 adjustment of status applicants. I'm not sure about this. You can correct me if I'm wrong.
It is correct.
You receive a letter. You're an investor. You receive a letter. You have no idea, right? You have just invested in rural. So what do? You call your lawyer, you call your attorney, and you say, hey, what is this choice? How do I make this choice? The simplest choice will be for you to just stick to what you've applied.
Right.
I think that's what's going to happen in a majority of cases, notwithstanding a few anecdotal cases of something else happening.
Well, and I think that Suzanne is telling us that that's probably, that'll serve the investors, probably, given the numbers. I mean, we already have cutoffs for Indians and Chinese in unreserved, and the rest of the world prognostication is not favorable with about 9,000 ahead. So I think, Dilip, you might want to just stick to where you are. Again, this isn't advice, that we're just talking, we're just kind of sharing out our observations, but this is very interesting, the question of the unreserved, and particularly for the rest of world folks, because you're kind of flying blind there. Okay, so let's come back to the main. Yeah.
I want to point out another aspect where experts disagree, and that is of the visible backlog of the people that we know are registered at NVC or have pending I-45, how many are actually still there? And that is a question that can make a big difference. Like IIUSA said that there were, or Department of State told IIUSA that there were over 8,000 Chinese with 2015 priority dates that were still pending at NVC this year. And most of those people, according to the Visa Bulletin, they could have visas by now. So the fact that they're still pending at NVC, does that mean that they still may get a visa eventually? Or does that mean that we can sort of discount them because maybe they've given up, still on the books? And
that's a good question.
People, this really comes up for India, because if you look at the Visa Bulletin dates, you would think, oh, wow, maybe Indians with 2022 priority dates can be getting visas a year from now. Whereas when I'm looking at the numbers and seeing that 5,000 Indians are registered as still in the backlog, I think, no way, that's going to take, more than 5 years to issue that many visas to that many Indians. But if in fact, the visible backlog
attrition,
people have given up but just not told NVC yet, then it could be shorter. So
that's a really good point. And the documentarily qualified, I mean, now we're getting totally in the weeds, but there's also the issue of how long folks are taking to get documentarily qualified, even if their priority dates are current, but they're just not prosecuting their applications. Then it's, they may not take down a number until some later fiscal year. And that kind of shifts the numbers and the assumptions a little bit. Okay, but let's pop back out, because now we managed to get into a level of minutia that might be a bit too technical. Okay, so just resurfacing a little bit more. Let's break down those numbers. So we have in the high end, 8,800 approximately. These are Lee's numbers using the upper end multiplier in HUA. And we have about, what was the number? 5,900 in rural. Let's break this down. So everybody's asking, right? All of our clients are asking, how many years are ahead of us? How do we apply what we know to that question? And then how do we also add in the per country cap analysis? So imagine an Indian prospective investor is asking us the question, okay, what's the queue ahead of me in both rural and high unemployment? What's our answer? And we could give a long answer. We really can, because the answer is there's no short answer to this.
First of all, high employment, 8,800. That's a little bit understated because 6 more months have passed.
Right.
So let's say 10,000, just for argument's sake, I think, right? Now 10,000 this year, that is 2025, financial year 2025, the high unemployment is just over 2,000 visas available, including the rollovers and everything. All right, let's assume that USCIS works feverishly to approve everybody, and then everybody is given visas immediately and everything. So 2,200 are used up. That still leaves around 7,500 to 8,000 people, visas, waiting for high unemployment. From next year onwards, there's going to be no more backlog and whatnot. So then what do you do? So every year it's going to be 1,000. So you're looking at, on a weighted average global basis, maybe 7-8 years of wait if you are the next applicant.
Do you agree with this analysis, Lee and Suzanne?
So I would say the short answer is it depends, because that's based on the case file, but a lot of cases are still pending. So IIUSA have actually collected a lot of processing time data from our member regional centers, and it shows a big spread between the shortest processing time for the 526E cases and the longest processing time for the 526E cases. So let's say if you're a lucky one, you just invest it today, and then maybe the shortest time is like a month. If you can have your 526E approved before February 1st, 2025, there is no backlog for you. That means like is the wait time is very short. So I guess my point is it depends on how fast USCIS process your 526E case. So if they do like first in, first out, I think I would generally agree with Dilip's calculation. So it's only 1,000 visas under HUA every year moving forward. If USCIS can use all of the available visa this year, which is like close to 2,300 visas for HUA, that means there's no rollover for HUA next year. And I'm pretty sure if there's no rollover this year, there will not be any rollover moving forward under this category. So that means only 1,000 visas every year. So that gives us like 6 to 7 years wait time for HUA.
Mm-hmm.
Adding in the factor of country caps,
Mm-hmm.
that if were born in China and India, whatever's the average, your wait time will be worse. And if you're from rest of the world, it will be better. Because of the possibility of potentially changing lanes and switching from high unemployment to unreserved, I think another thing to look at is just what if we weren't looking at rural high unemployment? What if just the 10,000 visas were available to anyone who filed this year? It's interesting to look at those numbers and realize that the I-526 filings this year create enough applicants even to exceed 10,000 visas, because there were almost 4,900 investments made this year. And so if this is almost 10,000, this would be demand for 10,000 visas if it was just only 2.
Let's spend just a couple of minutes on kind of the per country cap analysis. Yes, for sure. If you're an Indian or Chinese investor, the backlogs will be more severe, right? If you're from the rest of the world, maybe it won't affect you at all. Maybe even after there are priority date cutoffs established for Chinese and Indian investors and the set-asides, you might still be current. Can we just like zoom in on these points a little bit? Suzanne, tell us about the effect of the per country caps on these data points in the set-asides. What can you say about this? I mean, is there going to be like, will there be a cutoff first for Chinese versus Indians? Is there, do we have a feeling for which first? Is it going to be rural or high unemployment? So can you kind of just address the per country cap overlay to these numbers?
As far as when the per country cap becomes a factor, when there are enough people at the visa stage to max out the total visas available. So when Department of State has more than 2,200 applicants ready this year, then they'll start to hit pause on applicants from China and India to let other people go ahead. And when I'm trying to predict, who's going to get paused first and how long are they going to get paused, here it's very useful to look at the month by month pattern of I-526 filings and just see at what rate people came in, because this is also the rate at which people will be able to go out. in the past, we had first China got their cutoff dates and then India, and that reflected the fact that when people were filing I-526, first of all, there was a big crowd of Chinese, and then a few years later, there was a crowd from India. So China came up on the Visa Bulletin, then India. With these new categories, it hasn't been that way. Demand from China in India has been coming in concurrently at the same time, and also pretty robust demand from rest of the world coming in at the same time as well. So I predict China and India will have cutoff dates at about the same time. And it's also possible that rest of the world could get a cutoff date subsequently, just because there are enough people in line that if they all got to the visa stage at once, there won't be enough visas, even when limiting China and India to their 7%.
And that could be too, yeah. And that, but surely we must also make the point that based on the numbers, the cutoffs for the Chinese will be more severe than it will be for Indians.
Yeah,
right?
it will advance more slowly for the Chinese and the Indians.
And the cutoff will be at different dates.
I would actually guess that, well, yeah. That's an interesting question.
Right. Yeah, totally. Because if they started applying at the same time.
Yeah.
Yeah. That's about the volume might not matter on that point.
My hope and prediction is that they'll be very efficient issuing visas this year, but they won't actually get to the point where they're running out of visas until the end of the year. So I'm hoping that throughout this year, they'll just be able to issue visas first come, first serve, and not start limiting by country caps till closer to the end of the year, which really maximize the number of visas issued to Chinese and Indians this year in high unemployment. But
yeah.
If I may add on to this a little bit, I think the big unknown factor here is the 5 to 6 year approvals. So we have the case filing by month, thanks to the good work of AIIA, but we do not know the 5 to 6 year case approvals by month. So we don't know what type of 5 to 6 year case has been approved at this point. So I just look at the overall number. It's only, again, by the end of fiscal year 2024, that's the latest number that we have. It's only close to 1,200 5 to 6 year has been approved by USCIS. That's the overall number. So that, but what we don't know is how many of those cases are under high unemployment, or how many are under rural, and what's the
processing times.
Exactly, the processing time. Who are those investors? Are they all Chinese? Are they all Indian? Or are they all the rest of the world? We don't know. And I think this is the big unknown factors for analyzing the cutoff date, if there's any, on the Visa Bulletin.
Yep. Oh, guys, I mean, Dilip, we did our best on this question.
As far as investors are concerned, I would say, look, listening to this webinar, listening to all experts, they're all going to get into all sorts of details, different assumptions, and so on.
Yeah.
I would say investors should just look at, first of all, start with the headline numbers. If you're from China, we know how many petitions have been filed in rural, how many petitions have been filed in high unemployment, thanks to AIIA's FOIA. We have that number up to July. And I can tell you the numbers and just use 2.5 multiplier. It doesn't matter, right? So you still get a feel for it. I used a 2.25 multiplier. It's around 4,000 for rural for China. That's the number of visas, and 4,000 for high unemployment for China. That's your starting point. Remember that. Now that's up to July, and then you should bump it up a little bit more. Okay, even let's ignore that. How many visas are available, assuming there's a country cap? For rural, it is 280, right? It's 2,000. Yeah, no, sorry. For rural, it's 140, and for high unemployment, it's 7%, 70. So if you divide that, you're going to get a horribly high number. So start from that point. Then you're going to get the benefit of the visas from the rest of the world. But that's a very, very difficult calculation to make. So that will give you at least a feel for where you stand if you're the next investor.
Okay, that's a very good point. We can't be precise, but we can get a feel for the order, right, of the invisible backlog.
I would say from an investor's point of view, order of magnitude matters. It doesn't matter if it's 5.5 or 6.2 years, right?
Yeah.
You want to have a feel for it. Okay, I'm going to be stuck in this journey for 5-6 years, kind of.
Yeah.
And I'm going to invest my money. I'm going to get it back after X number of years. So you want to be mentally prepared for it. If 5 becomes 15, then you have a problem. If 5 becomes 6.5, yeah, of course you have a problem, but not that horrible.
Right.
So you want to have an order of magnitude number in your mind.
I think this is that's how I view it as well. And I once again, I'm very grateful for everybody here who's been responsible for getting the data and providing the analysis and sharing it publicly so that we can have a sense of that order of magnitude. Because otherwise, but for those things, we would be in the dark. Investors would be in the dark. So thank you very, very much. We've got to pivot. We could spend another hour on this, but we've got to do a hard pivot on some of the other points to highlight for this year. Let's talk briefly, and I think we'll just really have time for maybe one or two other highlights from 2024. Let's talk about the sustainment litigation and the point there. Suzanne, lay the table for us, or set the table for us. Can you just kind of briefly, like, tell us what the issue is and the state of play, and then we can have a little bit more of conversation about it from our different perspectives.
Okay, yeah, this is a thorny thing to summarize because depending on what perspective you have, you'll say what the issue is very differently. From my perspective, the major issue is the timing of repayment of when the investor can possibly exit their investment. And is the requirement to be invested a certain number of years, or is the repayment contingent on where you are in the immigration process, which is what it was historically. And you needed to wait until you finished conditional permanent residence before you would have the option. Mm-hmm. When the RIA was passed, it appeared to cancel out the link to the conditional permanent residence and to just instead give a minimum time period, say at least 2 years. And some people were really excited about that. I was really excited about that because for me, a big weakness of the EB-5 process is that the timing of the investment becomes very unpredictable and very long when it's linked to the immigration. And I thought, oh, this is great. EB-5 is going to be so much easier to sell and better now that it can have a more predictable time frame and it's not linked to immigration delay. But some people and the industry looked at this and said, wait a minute, 2-year investment? This seems like too short a time. And we liked it when the repayment was linked to the investor's immigration process. And we think that this is more consistent with how the program should be. And so there's this lawsuit out there that was filed by IIUSA to argue that the RIA changes did not change the sustainment period to simply make it a minimum 2-year.
If I may jump in here real quick. Of course, I'm not the most intelligent person to speak about litigation, but based on what I know, IIUSA is not excited about removing the linkage between repayment and the green card, but we disagree with the process. So how this memo came out is it overnight, it just appeared on USCIS website saying this is how we read the policy right now without any regulatory process about comments or about response to our comments. So this is a big red flag from our perspective about how the rule is being made right now. And from our position, we do not want the investments repayment to be linked with the conditional green card. We are very excited about these connections between the investment period and conditional residency. But we only wonder whether 2 years is the appropriate time frame for investment, for repayment, or for sustainment. So this is the big, I think, is a big misunderstanding about our position here. It's like we are not advocating for the old rule. We are just advocating that 2 years may not be sufficient to create enough jobs or sufficient to have the projects to be success. So we recommend it's 5 years, regardless the green card or regardless the immigration status.
IIUSA's action had two prongs. First of all, filing a lawsuit that the proper process was not followed, and therefore the 2-year sustainment period should not start at the time of investment or when the money is made available to the project, as USCIS had said. So questioning the process and therefore filing a lawsuit, that's one prong. The second prong was to request USCIS to come out with a minimum sustainment of 5 years. Now, I don't understand how they got this number 5 years from. Why 5 years? Why not 4 years? Why not 3 years? In the name of protecting the investors, they have specified a higher number. Investors are intelligent. Investors can make their own decisions. They know what project to invest in. They know what project not to invest in. So why not leave it to the open market? Who is IIUSA to specify a minimum time period of 5 years? That's how I look at it. As far as the first process is concerned, whether the process was right or wrong, I'm not a lawyer. Whether it's right or wrong, if that lawsuit succeeds, then all the investors who invested post RIA, they're all stuck. And that is incredibly negative to the whole EB-5 ecosystem. And I'm you know.
Dilip, can you make that last point again? Make that last point again. If how the post RIA investors was there,
because if the 2-year sustainment period, USCIS says that the 2-year sustainment period can start when the funds are made available to the NCE and then to the JCE for the project, let's say, you know, in simple words. Now, IIUSA is questioning, hey, how can you say this? Before you said this, you have not followed the right process. Therefore, just you cannot say this. Therefore, if USCIS is forced to take back its words, forced to take back its guidance, then we revert to the old system because there's nothing else in place. The old system is what? The old system is 2 years after you finish your condition, 2 years from the time you get your conditional residency. In other words, during the conditional residency of 2 years, you have to keep your investment sustained.
Right.
So if it takes 5 years to reach there, yeah, it's 5 years. If it takes 10 years to reach there, it's 10 years. We go back to the bad old system.
So I see. So you're saying that you're treating the post RIA investors like the pre RIA investors with
exactly.
Okay, gotcha. All righty. Well, that is it. That's exact. I mean, you guys laid it out beautifully. Not quite sure how this is all going to resolve itself. And does anybody think that we'll have an answer in 2025? I don't want to do too much prognostication into 2025, like I said, but I think on that's sort of, this might be an appropriate question to end this issue on, because there's nothing else to report.
Okay.
Do we think this is going to see some resolution in 2025, one way or the other, either via litigation? I don't see the service doing anything sua sponte by itself from a policy standpoint. It's announced its position, and unless forced to, it's not going to change that position. There has been some discussion about legislative amendment. I don't think that's really, I haven't heard anything suggesting that that's got any traction. And so as far as I know, the litigation is the only kind of event that can move the dial on this issue. Anyone else know different about it?
Well, this is right now at the lowest level of the legal system, the district court, right? District courts in DC. Now, the question is, there's oral argument scheduled in January. That's what I understand. And then the judge will do what I really am not, again, a lawyer. But it all depends on whether it can be appealed further And then how long is that going to sustain? How long it's going to take? I have no idea. But to me, it seems like the DHS is fighting this back with all its might. So they're not going to just give in so easily.
And then, of course, in the meantime, in this state of uncertainty, investors are having to analyze a very varied, I would say, investment ecosystem, right? Dilip, this is the point that you wanted to kind of have us hit in some fashion. It's that, pre-RIA, I think what investors were seeing in terms of the investments were kind of within a narrower range. They were mostly around 5 years, maybe +5 and 1 + 1 or something of that nature, very low, right? Sort of de minimis returns, like the rate of, not the rate, not return on. And I think we're seeing a lot more variance in terms of what the different projects are offering, in terms of the investment duration, in terms of the returns. Now, once again, this is more kind of on the investment side of the analysis than purely immigration side that we've been talking about to this point. But I want to kind of open the floor because I think investors would like to know your thoughts. What are you seeing and what do you make of it in terms of that greater variance of what's offered?
Just let me just make one point before I try to add some thoughts to that. First of all, to some investors who asked for my advice, I told them to read about the IIUSA website, the lawsuit to start with. Because if IIUSA succeeds, then they're going to be stuck for a long time, and they better be aware of it. Being stuck for a long time is only one thing. You look at an investment, you invest for 3 years, 5 years, whatever it is, you think it's a great investment, you think your money is going to come back, and then you go in. But then IIUSA lawsuit succeeds, then your money is being redeployed into another investment, which you have not looked at. You don't even know what it is. You don't know what its risks are going to be. Your money is going into some project which you may absolutely hate. You will have no control over it. It is a big risk point. Any potential investor should understand that they are facing this risk should IIUSA succeed. I have always advised people who have sought my advice on this. So that's one point. One positive thing is that post-RIA, after the clarification on the sustainment period from USCIS, we are seeing a lot, many more interesting project opportunities. There are more varieties of shorter investment periods for sure. Nobody looks at, those days of 6 plus 1, total of 8 years, all that's gone. Now, even 5 years, people are hesitating to put their money for 5 years. We used to get returns of 0.25%, 0.5%, less than 1% for sure. Those days are pretty much gone. People are able to easily look at returns of 3-4%, those kinds of ranges. There are projects that are able to offer preferred equity choices with even higher returns, profit participation structures. So if the project is extremely successful and makes a lot of profit, then investors are able to participate in it. So there is a much wider range of choices now available to the investors. I think it's all thanks to the RIA and thanks to the 2-year sustainment clarification. And I think it's more of a thriving market in the investment side. And I just hope it remains that way.
And you attribute that to the USCIS interpretation of the investment. Yes.
If I may jump in here, the first point I would like to make is I agree with Dilip that you should always check on our website. We have a lot of information on our website. Please use that as a resource. The second point I want to make is that for 5 years positions that Dilip just mentioned, we did not come out here from nowhere because we represent the regional center industry and our members have done thousands of projects. And it's based on their experience and their recommendation that 5 years is the sweet spot for projects to be succeed and for the cushions for the repayment to be made. So it's based on our experience actually based on our project experience on this. So it's not a random number. I would like to respond to that. And to Carolyn's question, it's great to see so many different projects right now after RIA. It's not just the number of years for sustainment periods, it's also the diversity of industry that EB-5 investment has been used. So before the RIA, we only see a very structured deal about building commercial real estate. But right now we have a lot of different projects in rural areas, a lot of different projects outside of commercial real estate. So it's good from our perspective to see EB-5 capital is being used for so many different areas. However, I'm not an investment advisor, but based on my regular Joe's thought is that I will never judge a project based on how soon it will repay you the capital. I would look at the whole factor of the projects, different risk factor, the business model. I think you should not just choose a project because you can receive your money quickly. I think it's one factor, but it should not be a detrimental factor.
Well articulated, Lee. Suzanne, what do you think about that? I mean, because I think the regional center and the projects, viewpoint on this is that, look, we're interested in protecting investors' principal, and it's very difficult to structure a 2-year deal that's a solid deal that's going to hit all the marks from an immigration standpoint and preserve the principal. This is what I hear. So what do you make of that? I mean, and then but then there's Dilip who says, okay, but investors or big people, we can, don't be so paternalistic, right? We can evaluate the risks on our own. What do you think, Suzanne?
Well, it is important to keep in mind that the 2-year, which is set by the law and reiterated in the USCIS guidance, it's just a floor. It's not a ceiling. And so nothing is preventing people from offering 5-year deals or 7-year deals or whatever and explaining that this is the repayment period that's appropriate to this kind of project and will allow us to repay, will give time for the project to create jobs and be profitable. So I don't see that the government policy is forcing a particular timeline on the industry. I think the concern with the sustainment lawsuit is that what if we went back into the bad old days situation where you couldn't get repaid until you got a visa? And that is a bad old days we don't want to revisit right now when we're looking at high unemployment is north of 7 to 8 years, according to Dilip's calculation, quite a bit more than that, in fact, for China and India, unless there's a lot of reshuffling. So you don't want to be going by surprise into, I can't get repaid until 10 years from now. And the inevitability of redeployment during that time. That's the wait time. Even if it were a tolerable immigration wait time, it becomes a really scary wait time if the investment repayment is also conditioned on that. So in my mind, what's at stake in the lawsuit is not, is a 2-year time frame or a 5-year time frame more appropriate? It is a question of, is it appropriate to make repayment contingent on the visa timeline?
I like how you cast that. All right. This has been amazing. I feel like we really covered the visa numbers issue in a really helpful way and imparting greater understanding about the invisible backlog itself and what the data points are that we look at. And hopefully that's helpful to people. And thank you for your insights on the sustainment period litigation. That's, I think Dilip and Lee, you've presented both sides of that very fairly. And Suzanne, thank you for your perspectives on that as well. And there are just a couple of questions that I just want to hit really, really quickly. Folks are asking for Suzanne's article. Everybody will get a link to that. It'll be in the link below on the recorded video, and folks who've registered will also get it directly. There were questions here about understanding reserve versus unreserved. There's a lot of information out there about it. We will provide some resources on that divide in the links below on the recorded video. And if folks on the panel have resources on that question as well, please feel free to forward to us, and we'll be sure to include them.
Make sure to put Lily's EB-5 Visa dashboard page on the links below.
Oh, definitely. And
a lot of data that will be useful for people.
And Suzanne, your spreadsheets, I mean, it's a lot of raw data there. So Suzanne, if you can point us to like some analysis and takeaways that are like a little bit more readily accessible, that would be fantastic. Another plug for Dilip's book, which is available on Amazon.com, from the Investor's Experience. I commend that. And thank you everybody for listening to the year-end in EB-5 review with us. And the next one will look ahead to 2025 in EB-5, year 3 in RIA. Thank you so much. Thank you, Dilip. Thank you, Lee. Thank you, Suzanne.
Thank you.
Thank you, Carolyn. Thank you, guys.
Thank you. Bye-bye.
Happy New
Bye-bye.
Year.
Happy New
Happy
Year.
New Year, everybody.
Happy New Year.